I apologize real quick, Ms. Herrera. I gave you 2 minutes out of about a minute and a half.
That's fine.
I'm sure you recognize that.
Anyway. Thank you.
All right. Is it Ms. Richardson?
Yes, present here, Your Honor. May it please the court, Latasha Richardson, representing minor child CC. Your Honor, my client has not committed any crime here, and there's no evidence that a crime has been committed. What we have here is a questionable investigation by an overzealous school police officer, an alarmist math teacher, and a hypervigilant prosecutor, more focused on a conviction rather than the truth. Because Section 502c3, as described in Chrisman v. City of Los Angeles 2007, the court very clearly describes the legislative intent. The court said that PC 502 was to deter and punish browsers and hackers, outsiders who break into computer systems to obtain or alter the information contained therein. The court further stated that, underscoring that accessing a computer's logical, arithmetical, or memory function is different from ordinary everyday use of a computer to which people are accustomed when they say using a computer. One reason.
I guess one of the things I'm struggling with, counsel, is as I read the statute, I mean, the critical portion of the statute is whether the computer was knowingly knowingly used without permission. And we have these Chromebooks that are provided to students for a very specific purpose. And your client was well on notice of what that specific purpose was. In fact, I think the record shows that he was spoken to about inappropriate use something like 5 to 10 times. So it seems that it potentially fits within the statute. And again, what I referenced with your colleague is you bear a very heavy burden in challenging a conviction for insufficient evidence. So why wasn't this a knowing inappropriate use without permission of the school?
Well, first and foremost, we have consent. The school consented to him using it. We've talked about the fact that there's undisputed that he was to use that computer for his math Desmos program. The teacher was there. We have no documentation to prove that what the teacher is saying is true. If he has spent 5 to 10 times redirecting this child, because he was talking about a 14-year-old boy. If he spent all this time, where's the documentation? There's been no parent-teacher conference. There's been no interaction from the principal, the vice principal, the dean. There's no documentation. This is just
counsel,
his work.
If I can stop you there, didn't the teacher, my view of the record, I'm assuming the teacher testified at the jurisdictional hearing. Is that correct?
Yes, he did testify, Your Honor. However, he's not an expert witness. This teacher is he's a percipient witness. He testified on what he saw, but what's in the record is actually expert testimony. And so that testimony shouldn't have been admitted, because he can't speak to the way that the computer is accessed. He can't speak to the mechanics of the computer, the operational system of the computer. That's outside of his scope. He's a math teacher. He's not a computer science teacher. He's not a computer engineer. There's no documentation to prove that he has the skill set to be able to speak to what's in that computer.
Can I go back? You talked about the school giving the minor consent. It strikes me that the potential issue here is one of scope of consent. So I fully agree that the minor was given the Chromebook for the purpose of doing schoolwork, but clearly wasn't given the Chromebook for the purpose of looking at this inappropriate material, certainly not in class time. Does consent get you far enough? Because the actions seem way beyond the scope of the consent.
Your Honor, normally I would agree with you. What I want to say is this. The defense doesn't even know what a school shooting simulator is. The people have not put forth that evidence. We don't have the computer. I've never seen an asset tag number. There's no metadata. There is nothing to show that any of those things were accessed. What I believe, or what the evidence is showing me, is that we have a frustrated math teacher who is just disgruntled with this child because he's had to redirect him. More importantly, Your Honor, what we don't have, which is most important, is we don't have a school policy. We have no policy to say that this type of behavior was prohibited. We have nothing from the client that is signed. We have nothing from his parents that is signed. So we have no information to show us that what he did was wrong. He came into the school in January. What it shows me is that in August of every school year, when children start, they are issued a school computer use policy, and we don't have that. So we can't hold him to a standard. The school is the issue here. And I think that
I think, counsel, one of the things I'm struggling with is, especially on review after basically the juvenile equivalent of a conviction, mm-hmm. a lot of these issues are settled. You seem to me to be fighting with a lot of the facts that were settled at the jurisdictional hearing by the Superior Court. I'm not sure it's within my purview, just reading a cold record, to relitigate some of those facts. For instance, what we discussed, the teacher testified and the Superior Court mm-hmm. found it credible mm-hmm. in convicting your client. I guess I'm struggling with what to make of your challenge to some of this evidence.
Well, counsel raised an objection. And counsel raised multiple objections to this information being submitted before the court. And so I'm not trying to relitigate that, and I'm not trying to move this court. I'm giving examples as to there is more than one issue here, and it doesn't all stem with this child. And I think that it's repugnant to public policy to give the school that much latitude to be able to pull a child into an office, search his backpack, without even a articulable facts of what is a school shooting simulator. I mean, if we're going to talk about this, and if we're going to, change policy, or we're going to enact and push 502c3, then we actually have to have some evidence. And so the defense counsel is struggling here, trying to figure out what crime has actually been committed.
Okay, counsel, that's your time. You can briefly conclude if you wish to.
No, Your Honor, I'll save my rebuttal if you don't mind. Thank you.
Of course. All right. Well.